I'll go to the next speaker now, Dr. KP Singh. Dr. KP Singh is ex-DGP of Haryana. He has also been DG Prison, DG Anti-Corruption Bureau, DG CID, DG Human Rights. He has been part of MHA's expert committees on criminal law amendments as well as modern prison manual. He holds a PhD in the law. He has 25 books, 17 research articles, including 4 monographs to his credit, and got awards from the Haryana Sahitya Academy as well as BPRND. At present, he is a distinguished professor of law with the NLU at Patiala, and regularly teaches at the Army Law College. So the topic given to him is, although there are sufficient laws, but can there be further law amendments that arrest only with warrant? Secondly, can there be arrest only by SI and above, except in violent cases? And thirdly, how do you fix up the accountability and compensation for the wrong arrest? Dr. KP Singh, please.
Thank you, Dr. Ish. Am I audible?
Yes, you are audible.
So thank you very much for your kind words and for giving me the opportunity.
Dr. KP, 12 minutes, please.
Yes, I will try to complete it. So it's always a very difficult task to speak at the end.
I know.
Because all the relevant points have already been covered by the distinguished speakers.
Very true.
But still, I will try to make those points which remained uncovered so far. I have a small presentation. I will try to share it. If I could not share it, I will go without that sharing. See, the question around which we are discussing throughout the session is arrest laws. My basic starting point is, are we arresting too many? In the morning session, Mr. Ramphal has already given you the statistics. Out of the 44 lakh IPC offenses, 24 lakh were in other IPC crime and miscellaneous crime, means unclassified crimes. This proves that 60% of the offenses in which we are resorting to arrest were not actually required. I have another statistics to quote from prisons in India, and that says that 35% of the prisoners were bailed out in 3 months, and another 19% were bailed out in 3 to 6 months, meaning thereby 55% of the prisoners were bailed out within 3 months. And they were those arrestees who were arrested either for those offenses which were compoundable or those offenses where punishment was less than 3 years. Another statistics which Mr. Ramphal gave was that 76% of the under trials are under trials. In fact, that is a curse to the statisticians, because statistics reveal less and hide more. If I actually calculate it on the basis of footfall of under trials and footfall of prisoners in the jail, it comes out to 90%. 90% people who are entering into the jails are under trials, and 10% only are the convicts. Starting on these basic statistics and expressing concern, in Joginder Singh's case, the Supreme Court has already said that power to arrest is different from need to arrest. And this is what we have been discussing since the morning. Law mandates that arrest should be need-based. When this question was confronted in England, Royal Commission was constituted in 1960 and it submitted its report in 1962. And the commission gave important suggestions in the form of appearance notice as a substitute to arrest for the purpose of interrogation. The commission also recommended that there is no need to arrest a person for fingerprinting or for test identification period and for interrogation. We have adopted the appearance notice, But still, we have to go further to not to resort to arrest for the purpose of fingerprinting, for test identification period, and for interrogation purpose that I will discuss in the last part of my presentation. In fact, groundless and needless arrest, since the morning it has been said by different speakers, is beholden to the mindset of the stakeholders. The stakeholders are the police, the judiciary, the politicians, the complainant, the general public, the prosecutors, lawyers. Everybody is a stakeholder, and nobody is interested to reduce the number of arrests. And police was developed as a tool of governance over the years, we all know. None wants to forego this tool, and such a tool which is obedient, always obedient. So therefore, we have to think about way forwards whereby we can change the mindset of the stakeholders. I'm not going to discuss here to change the mindset of the other stakeholders, but I'll only talk in terms of the changing the mindset of the police officers. And changing mindset is possible either by giving strict legal prescriptions, or by limiting discretions, or by infusing strict supervision, or causing deterrence by way of strict judicial and supervisory scrutiny. I'm leaving apart all those points. I will only discuss as way forward how to limit the discretion and what changes in the law can be made. My first suggestion so far as changing in law is concerned is revisit section 41(1) subsection B. In fact, the amendments in 2019 were introduced with half-hearted measures. What one hand gave, the other hand took it back. As per section 41(1)(B), offenses entailing less than or equal to 7 years of imprisonment, the IO is given wide discretion to justify arrest. And he need not to go anywhere. Section 41(2) gives the list. What are those reasons? He can list any one of those measures and he can arrest a person. In fact, in 2009, when these amendments were done, there was all India strike of lawyers, and the strike continued for 1 full year. The working of the court came to halt. And in 2010, another provision was added as a result of that strike, and it was added that IO shall give reason for not arresting, meaning thereby the onus was on the IO. And why the IO will like to give his explanation that he is not arresting? He is at the danger of being accused that he has taken money and all other consequences. The import of all these amendments, or this particular amendment after the lawyers' strike, is that there is nobody who is interested in reducing the number of arrests. And it is a reflection of the mindset of the stakeholders of the criminal justice system. I suggest here 2 amendments by way of proviso in section 41(1)(B, and I read it. First proviso: provided that in all cognizable offenses which are compoundable or triable as per summary or summons case trial procedure, means where punishment is up to 2 years, the IO shall not arrest a person and release him if taken in custody for investigation within a reasonable period, but not later than 8 hours in a day in any case. Second proviso which may be added is provided further that in case of arrest of a person in a cognizable offense punishable with imprisonment up to 3 years, the IO shall release the person on bail with or without surety or on his personal bond by exercising his power under section 437 of this code. If we do these amendments, we can reduce the number of arrests at least by 40%. Another suggestion is section 41(a) subsection 3. Mr. Barakat Ali Saab discussed in detail about notice of appearance. This provision also needed revisit. It reads, where such person complies with the notice, he shall not be arrested. One hand gives. Another hand takes. In the second part of this section, it says, unless for reason to be recorded, the police officer is of the opinion that he ought to be arrested. What has been given by the first part has been taken back by the second part. The IO can very well reason that he need to be arrested and can arrest the person who has attended him after getting the appearance notice. Again, the wide discretion has been given to the IO. Here also I have proposed an amendment. For this second part, unless for reason to be recorded, the police officer is of the opinion that he ought to be arrested, I suggest that this part may be replaced by these lines. And I read that if the IO forms an opinion at a later stage that the person under notice of appearance of an offense entailing punishment up to 7 years of imprisonment need to be arrested, he shall give a reason, he shall give reasons and notice to the person and obtain written permission from an officer superior in rank of the officer in charge of the police station. Provided further that no such notice or permission shall be necessary if the offense is punishable with more than 7 years of imprisonment, just to make sure that heinous offenders do not take advantage of this provision. Third amendment which I suggest is in section 41A(4) CRPC. This provision is again vague, loosely drafted, and give wide discretion to the IO. And by way of amendment in 2010, after the lawyers' strike, 2-3 words were added to it: unwilling to identify himself. The IO was given discretion that if a person is unwilling to identify himself, the IO has the power to arrest him. The IO can very well say, he did not give me his identity, he did not provided me his address, and arrest him. For that also, I am suggesting an amendment in place of this section, or a provision may be added that provided if the offense is punishable with less than or up to 3 years of imprisonment, arrest shall be made only after obtaining written permission from an officer superior to the rank of the officer in charge of the police station. And an explanation may also be added to it that Aadhaar card shall be sufficient to establish identity. Another suggestion is arrest for the purpose of section 27 Indian Evidence Act. There the word used is in police custody. Police custody never meant that the person should be arrested. In fact, when this provision was drafted in 1872 by James Stephens, arrest was the only means to take a person in police custody. But later on in independent India, in Empress versus Lister, in Paramhans versus State, in Harikishan versus State of Haryana, in Empress versus Mangal Gowda, the Supreme Court has held that if direct and indirect control of police has come over the person, it would amount to police custody. So where is the need to arrest a person for the purpose of section 27 IEA? You summon a person by giving him a notice under 160. Technically, he is to be treated in police custody. Interrogate him, whatever you want to write him, recover him, and leave him. But since this tradition is continuing and nobody has thought about it, it should be engrafted in the provisions by way of adding an explanation in section 27 Indian Evidence Act. And I read that explanation, proposed explanation. For the purpose of this section, formal arrest is not necessary. Police may seek custody of a person after issuing him notice under section 160 CRPC or otherwise. This will reduce lakhs of arrests, because that will do away with the provision of arresting a person for the purpose of effecting some recovery and making the confession made before police admissible. Another aspect or another amendment is there is mandatory requirement of arrest for getting a person medically examined under section 53 CRPC, for test identification paid under the provisions of section 54A CRPC, for taking handwriting or signature sample under the provisions of section 311A, and also for taking measurements of a person, including photographs, etc., as per the procedure of Criminal Procedure Identification Act 2022. All these provisions entail that the person should be arrested first. Why can't we make change and instead of arrest, change the law that the person should be taken in custody? Person can be summoned, he can be medically examined, test identification period can be held, his handwriting sample can be taken, and after that he is released. So where is the need of taking that person or arresting that person? And similarly, on the pattern of section 27 Indian Evidence Act, the explanation which I have suggested, an explanation may also be added along with these provisions. Arrest to verify name and address. 96 to 97% of the people have their base biometrics recorded with the Aadhaar authorities. But the Aadhaar authorities are not sharing those biometrics by following the principle of doctrine of purpose limitation. Honorable Home Minister have on a number of occasions have said that this doctrine should be do away with for criminal investigations. There is a need that this doctrine should be do away with for criminal investigations. After that, the data is available to the IO on his desktop. He can verify from the Aadhaar card his identity very well. And let me quote one example, Ish. There was a controversy about Ram Rahim recently. It was argued in the High Court that Ram Rahim is not the same person who is undergoing imprisonment, who was convicted. The prison authority, what they did, they matched his fingerprints with the fingerprints taken in the court when he was convicted and issued a notice that he is the same person. So if that Aadhaar matrix is available at the police station level with the IO, they can very well verify the identity, and there is no need to arrest a person for the purpose of identifying him. Last amendment is in section 109 and 1110 CRPC. I was aghast when I listened from Mr. Ramphal that still 19 lakh people were arrested in India in 2020 for 109 and 110 CRPC. It is grave illegality. Dear friends, in 2010, section 41 subsection 2, which allowed the police to arrest a person on charge under section 109 and 110 was repealed. Now there is no provision available for police to arrest a person under 109 and 110. And I am surprised why the NCRB is still continuing this and legally justifying it that they can arrest it. Nobody has read it. Nobody has gone through that amendment clearly. Similarly, under section 151(2) provides that the person arrested under 151 CRPC shall be released when no more required. And the Delhi police is using it in the recent context, taking person in custody and releasing him in the evening. Why we are taking those persons to court and arresting them formally? Why can't we take bond from them and the IO can release them? Appropriate guidelines may be issued on these aspects. These were some of the amendments which I wanted to suggest. Last 2 minutes, I will discuss about the accountability part. Accountability means nothing if there is no desire and intention to impose it. Mr. Barkat Ali in the morning has said that in Andhra Pradesh, some persons are facing contempt of court. But that is not the case everywhere. In most of the states, the courts are not taking cognizance of informal arrest or illegal arrest or improper arrest. It will be interesting to note how many magistrates have been hauled for contempt as per Arnesh Kumar for not ensuring that the guidelines of Arnesh Kumar are followed. How many police officers have been dealt with departmentally or criminally if they have not followed the guidelines of arrest? And this substantiates my point.
This question answer session, I can hand over
The
to
SOs are reluctant, the
and
magistrates
my
are
own
indifferent,
session, I will,
sufferers are
5
ignorant,
minutes.
and IOs are fearless. And this fearlessness, when coupled with ignorance of law, become a deadly cocktail and is resulting in those number of arrests which Mr. Ramphal mentioned in the morning. To infuse accountability, perpetrators pay principle should be followed. No sovereign immunity to the IOs, no protection of section 197 CRPC, and for illegal arrest or informal or improper arrest, both civil and criminal liabilities are attracted. Criminal liability for violating of law under section 166A IPC, and criminal liability for procedural lapses as well as for damages under the law of torts. And of course, departmental inquiry for supervisory lapses. And the question or the duty to impose these liability rests with the supervisory officers, with the superintendent of police, as well as on the courts. So we have to change the mindset of the superintendent of police, the supervisory officers, and the courts. There is one important provision, and that will be my last suggestion. That is section 358 CRPC. It provides compensation to person groundlessly arrested, but it asks only the complainant to pay the compensation, and that is also 1,000 rupees. I have suggested modification of this section so that it acts deterrence on the IOs also. And I read, and I will finish with that. I read the proposed draft amendment of section 358(1). It says, compensation to person arrested disobeying direction under law. Title is changed. It says, whenever any person causes a police officer to arrest another person, if it appears to the magistrate by whom the case is heard that there was no sufficient ground to cause such arrest, or the person is arrested by a police officer disobeying direction of law, the magistrate may award compensation to the person arrested not exceeding 25,000 rupees to be paid by the person causing such arrest. Additionally, the magistrate may also order the police officer making such arrest to pay compensation to the person arrested not exceeding 50,000 rupees at any stage of the proceedings. This is the amendment which I suggest. I conclude by saying that this workshop has given us a wake-up call. A wake-up call which the Supreme Court recently have also given us. And the fire has reached to the doorsteps of the top cops. Many top cops are already suffering the burn. I need not to explain. Let us not ignore or support illegal action of our subordinates. Police is an instrument of law. It should remain so always and forever. And I conclude by saying that let the process not become the punishment. Thank you very much, Ish, for giving me the opportunity. And thank you, IPF.
Thank you, Dr. KP Singh, for a very erudite and detailed suggestions on amendments to the various sections of the law. I will suggest and I will request Mr. Ramchandran that it is better that we hold a separate session where physically we can meet in a smaller group of 10 to 15 officers, discuss each of these suggestions given by Dr. KP Singh as well as the other speakers, and then take a final call on all those suggestions and amendments before we forward it to either BPID or MHA. So thank you very much, Dr. KP Singh. It has been excellent listening to you and shows your profound knowledge of the law.